Hello everyone, my name is Aisling McPartland and I'm part of the marketing team here at InfoTrack. Today's webinar will look at the changes to the Law Society's Conveyancing Quality Scheme, and I'm joined today by Sarah Keegan from the CS Partnership. In this session, we will review the motivation behind the Law Society's changes to the Conveyancing Quality Scheme and the future proposals. Before we begin the webinar, which should take no longer than 30 minutes, I'd like to draw your attention to the box on the webinar software, which allows you to ask questions as we go through. Type them in here and we'll answer them at the end of the webinar. And I will now pass you on to Sarah to present.
Thank you very much, Aisling. It's really nice to be here with you all, and it's lovely to be speaking to you. I have to say that I think it's going to take me 30 minutes, but I have a tendency to talk a little bit, so it might be a little bit longer, but I will try and keep it in the time that we said. And just before I start, you can see that the first slide is all about me, but partly because it calms me down. It's something that I know how to talk about very easily, and I always put that first, but also because I find that as a lawyer, I wouldn't necessarily like people who don't understand how the pressures of practicing affect us all, and how much of a combined unit we have to do every time we move even one conveyance. So I just want to tell you a tiny little bit about myself. I qualified in 1996, and back in the day, I used to run 4,000 transactions a month in conveyancing and remortgaging. So I've been probably in every pain point that you guys have been in, if not more, actually. But let me get on with what we were. Let me just turn up the volume. Is that better for you? Can you all hear better now? So let me just start with the Law Society's, turning onto the first page. The Law Society is changing to the conveyancing scheme. Now let me check, because, let me see, it's not moving the slides. So I am controlling it. There we are. I thought I was about to have my worst nightmare come true there, but once I worked out how to do technology. No, ironically, just while we're talking, ironically, of course, I am a lawyer who now builds IT systems, and I'm not being able to very easily manage the slides here. So, can you all hear me now? Yeah, good. Let me go back in my slides because I'm making a bit of a mess. Right, good. Everybody, can you hear me? Good, right, let's go. Apologies for all of that. So the first thing I've done on the slide is just to put up the Law Society's actual link to their webinar. You do get the slides at the end of the webinar, don't worry about it. So let me start properly and stop fiddling around with the slides. Okay, I've put the link into the Quality Conveyancing Scheme from the Law Society, not because you all don't know how to find it, but because I thought I'd be thorough. And as you well know, probably from that already, it has the details of the core practice management standards all available at the Law Society. And there's quite a good document, if any of you are set up with Lexel Standard 6.1, and there's a good document that indicates the overlap between Lexel and the CQS. It's a good comparison. And more than that, it's also very useful about who you need to be training in your firms and how often they need to be trained. And I quite like all of that. But this, of course, is a chat more about not necessarily what's written on the CQS requirements, but the driving forces behind it, and then what I would have put into, or what I have put into the policies that are especially needed in this particular new requirement. So one of the things that I like talking about is the driving force behind the changes coming through conveyancing. And before, the reason I told you about my background at the beginning is because, quite frankly, if I was sitting here lecturing you about the changes coming and how you all need to get faster, sharper and better, and looking at AML and all of that sort of thing, without telling you that I understand your pain in all of it, then I think I would be yet another person in the industry lecturing about what we need to be doing as an industry and why everything is, getting sharper. But one of the driving forces behind the Law Society changing the CQS was that, as you know, it was set up in 2011, and in the Law Society's own words, it was to provide a trusted community of solicitors within the residential conveyancing market that helped to deter fraud and improve best practice standards, which sounds amazing, doesn't it? But as we all know, VEO sounded amazing. And the problem with CQS to date is that it was basically a tick box exercise. In the history since 2011, only 2 firms who applied for CQS accreditation have ever been rejected. And there's never been any inspection or enforcement actions from them. And a solicitor in 2016 who knew that it was being portrayed to the public as something it wasn't, complained to the Advertising Standards Authority. The Law Society at the time was advertising CQS as a recognised quality standard. It still does, actually. But the Advertising Standards Authority found that the Law Society had exaggerated the level of knowledge, skills and experience possessed, and the extent of the checks that a firm... Oh, hang on, Okay, hang on a second. Natalie, can you hear me more now? Natalie, can you hear me better now? Sorry, everybody, but Natalie can't hear us, and I just wondered a bit. Okay, fine. Oh, that's worse. Right, okay. All right, hang on. Okay, now listen, can you hear me a bit better before? Right, okay. I'm going to talk really loudly and really slowly and really clearly, okay? But if you have any problems, I'm not going to panic about this. I'm just going to very calmly carry on. So keep calm and carry on. That's what we all do, isn't it? Right. So what I'm basically trying to say in this first screen is that the Law Society was held to account, basically. And what they have done is take from 2016 until 2019 to bring together their new requirements. And one of the things that they're going to be doing is starting to desktop assess and inspect as well. I'll come on to that later. For now, I'm also going to tell you about some of the other driving changes behind coming. And I'm just waiting for my screen to upload. I think I've done it. There we go. Now, the other driving changes behind all of these changes coming is the fact that although anti-money laundering and anti-risk has always mattered, we are now going to be held more accountable as a profession. And I understand that you'll come back to me and say, it's not what we trained to do. We've already got a job that's bigger than most people can possibly imagine, and we're adding to it. But here's why some of it is coming at us. There's £100 billion a year being laundered through the UK every year. And it's estimated that 39,000 serious crime groups exist in the UK. And I always laugh a bit at that because obviously they don't put their hands up and say how many of them there are, but there are estimated 39,000. And Donald Toon, who you might have heard speak at the SRA's seminars for culps and coffers a couple of years ago from the National Crime Agency, refers to solicitors as and other legal providers as professional enablers. So we're faced in the UK with pretty much the toughest legislation in the world on anti-money laundering, and yet last year we submitted 2,660 SARs, which is a really small amount considering that £100 billion is being laundered through the UK bank accounts. And in contrast to that, it looks like, thankfully, there are a very small number of bad solicitors, so solicitors who specifically help fraudsters. I was going to say baddies, but that sounds really immature, doesn't it? Only 60 firms were referred to the SDT last year for potential improper money laundering movements, and only 40 solicitors were struck off. So it's tiny. But what NCA says is that we as a profession are unwittingly involved and that we're turning a blind eye. And unfortunately, we're conveyancers, and therefore we move more money than most of the other colleagues that we've got. FATFA, which is the Financial Action Task Force, is a global body, and it came to visit the UK in 2018 and found that there were vulnerabilities in the legal sector, which of course there are because we have client accounts, but the other reason, and because we move money through our client accounts, but the other reason that we were deemed to be vulnerable in the legal sector is partly because of the Panama Papers and the fact that it quite clearly became obvious in the Panama Papers that solicitors were assisting their clients to avoid tax payments, which means that we are possibly assisting clients do all sorts of things. Now, I'm not suggesting that we are in conveyancing, but that's what they found by what FATFA found. And one of the other things, which I think is even more important, if that's the case, is that the SRA is now being held accountable by OPBAS since 2018. OPBAS is the Office for Professional Body Anti-Money Laundering Supervision, set up last year, and it's basically leaning on the SRA and the CLC and anybody else to say you're not holding your firms accountable enough, because £100 billion a year is being laundered and it's not being reported in. And consequently, it must be that although you're all writing great policies, or you're all writing great things that the firms need to hold up themselves up to, it's not actually being done at the coalface. And this is where I really wanted to talk to you about it, because at the end of the day, what we've got to do is, yes, you're on here to talk about the new policies, and I'm going to go through that, but also it's about how do you hold it accountable at the grassroots, at the coalface is what I usually say. Both the SRA and the Law Society will increase their inspections and follow-ups. I'll come back to that later. And can I just tell you, before I move on to the requirements of the new policies, that we've had, we work with clients who are now who weirdly, it's either, I don't think it's because of us, but they're now, their Lexel annual inspections are harder for them, specifically with regard to risk. I'll tell you about that actually, because it's interesting. And also the SRA following up on them. And the CQS amendments are the Law Society coming together into the same playing field and saying we need to really sharpen up on this. So I think you've got some time. I think it takes the Law Society a while. I'm going to really be told off for some of this, aren't I? But it takes a little bit of a while for the Law Society to warm up to most things. For example, they brought in, they brought in their new requirements on the 1st of May, and their own toolkit doesn't come out till July, so that'll tell you what it's about. But at the end of the day, it's something that we need to be looking at. And one of the biggest tips that I can tell you that we're finding in our business at the moment is that if you're doing risk assessments, and we train our staff and we all have to look at risk, you need to be doing them 3 times per transaction. So 1 at the beginning, 1 in the middle, say on before exchange, and 1 before completion, because money laundering doesn't actually happen until you send money. So keep doing the risk assessments, but more than that, what Lexel seem to be really wanting to see is written evidence that they were properly conducted, and written evidence that somebody thought about it. So I'm not suggesting, and I always say this to law firms, it's not that you're going to be able to manage to avoid every single risk that's thrown at you these days with cyber security and hacking and Friday afternoon fraud and who's your client and anti-money laundering, and the risk is now on the seller from the 1st of May with the code of completion to prove that you are, or to take the liability for you having to check that your seller is who they say they are, and all of that. That is a huge area for you to deal with as practitioners. And I'm not suggesting that you're ever going to get it right. But what I will say is that if you have put some of these policies into place and then you force them, you take the policies out of the air, so to speak, and actually put them into the ground of what you want your staff to be doing on a transaction basis, on a daily basis, and train them, then you will be able to sit in front of your indemnity insurers, the SRA, the NCA, and whoever else that sits in front of you, should something go wrong, and hold your hands up very clearly. And none of the bodies that we are dealing with and come into contact with will ask you more than that. All they want to know is, have you done your very best? So I'm sorry, because I always have to talk like that. And the reason I have to talk like that is because I really get that it feels like who in their right mind would carry out doing property these days. But it is a worthwhile practice area. I absolutely love it. If you cut me open, I'm a property lawyer by heart. And, it's just a case of being so organized with what you will and won't accept, and being able to say really strongly, we don't want to act for this client. And that's a real thing that we lawyers hate, isn't it? Because we're all trained to get more and more work in and never turn a client away, and you've got to be mad if you don't want to do it. And in this day and age, I think it's something that you really can say very clearly, we don't want to do that. We're not acting for that. It's too big for us. Or one of my clients is now currently saying in their engagement letters, our fee is X, but if we find out that we need to do more anti-money laundering checks, then we reserve the position to be able to charge you more. And I think that's fair enough, because this particular firm can tell you that if they have, for example, money coming in from China, that it will take them another 4 or 5 hours internally between them all to check that that's acceptable and that they're going to proceed with it. And that's something that I think you can definitely charge for. So moving on from my soapbox, which is a very familiar soapbox to me, and you might well be raising your eyebrows to heaven thinking, just get on with it. I'm now going to turn to the main additional policies that you will need to be writing, if you haven't already, for the CQS. The first one is the SDLT policy. Now, the requirements from the Law Society are that you need to have an audit trail to have an SDLT calculation and advice, and you need to know how and when to make checks between the consideration stated in the sale contract and the transfer deed, and a process for verifying the SDLT. Which is, you read that and it's fairly innocuous, isn't it? But when you think about what you need in an SDLT policy, I think you should also add to it that the SDLT rates are subject to change, and somebody in the department needs to be in the policy appointed as responsible for checking the rates and for updating any applicable systems within the firm. And those systems might be your conveyancing quoting tool, your case management system, your client care letters in terms of business, your firm's website and brochure and pricing structures, and all of the training out to the fee earners, support staff and clients. And then if I was writing a policy, or I have written policies, but if I was writing it, I would put in there as well that your policy is that the fee earner must obtain sufficient information from the client and calculate the SDLT using either the firm's case management system or the SDLT calculator provided by your search providers, or alternatively going on to SDLT on HMRC and doing the calculation. And at that point, saving a copy of it down and ensuring that it's either on the file electronically or on a paper file. Obviously, you'd also want to make sure that the SDLT amount is included in the quote to the client. And then I would also have a pre-printed SDLT advice sheet that goes out to clients with your initial packs that say what SDLT is, why the onus is on the client because it's a tax and therefore they were having to be signing it. They were having to be signing it. Goodness me, I do speak much better in person, by the way, than I am speaking on this webinar, but that they are responsible for signing it, just like if you're doing your own tax. Some information about second home rules and first-time buyers and higher rates. That's what I would send out in the SDLT advice sheet. I then think that you probably want to come on before exchange of contracts to have a statement or a policy that says the fee earner must again check the SDLT given at the beginning of the transaction just to make sure it's correct, possibly get it signed off by somebody before exchange of contracts, but also just to double check whether there are any circumstances that have changed. Update the calculation or double check it, produce a draft completion statement and an SDLT return form, and send them to the client for signature and approval before exchange. I know that might sound to some of you as though that's I'm stating the bleeding obvious, but firms don't necessarily do that, and I think it's a risk to not get a client to sign up before exchange. I always think about exchange as a bit like the point where beforehand a client might be persuaded to do pretty much everything, but afterwards might not be so inclined, or especially before completion, might not be quite as inclined to go ahead and do whatever you want them to do. So I think signing an SDLT return form and getting them to look at the draft completion statement before exchange is an absolute requirement, and I know that is what a lot of you do. So at that point, we then move on. Once you've gone on to exchange, you're past pre and post. You're into pre and post completion. You definitely want to make sure that you've told the client you're not completing without the SDLT money. I know some firms don't, and that always surprises me. Sorry if you're one of them, but you're then possibly held with the liability of not doing it. And again, it's back to the fact that a good client by that stage will be on to where the Christmas tree is going and how they're unpacking boxes, and you just want to sort the whole thing out before completion. I think you should have a policy that says the SDLT return should be made to HMRC within 11 days of completion, because it gives you a couple of days afterwards. And then, of course, you're going to be registering. That's all fantastic. One of the things I would put in your SDLT policy is that if the client has possibly paid higher rates because they have additional properties, then what you want to be doing is telling them, probably at the end of the matter, that if they sell their main residence within 3 years from the date of completion, that they might be able to claim it back, and to give them their special unique tax transaction reference number to be able to do so. One of the firms that I work with at the moment is actually advising clients that they will make that claim back for them. I kind of don't like that. I'm not sure if you let me know about what I say, by the way, if I'm on the right path with you or not on the right path, or you do things differently. But I don't really like that. And the reason is because it's a tax. And again, we are then being very responsible, aren't we, for telling the client and dealing with their tax. And I think they could do that themselves, but that's up to you. And then finally, in the SDLT policy, I think that you need audits, or say that you are going to audits and do file reviews by your head of department, and that you will look at the pricing and the website from time to time, the way you quote, the way you do your client cares, and the authority letters and the matter checklists, and the advice that goes out to clients. And I think if you include all of that, you would be very happy with your SDLT policy. So the next one is the next one I've picked up on is the mortgage fraud prevention policy. It's not new. You'll have them already, but I thought I'd pick out some of the major points in the new bits that are included in this requirement. Oh God, I say oh God because my slide has gone backwards. Let me just carry on as I was doing, and the slide will catch up with me. So the requirement 1.4 is for a property and mortgage fraud policy. It's not new, as I said, but it does include relevant checks against the conveyancer. And I have to say that one of the things I would advise all of you to do is to be doing lawyer checker searches. You will possibly not be doing lawyer checker searches because you will be doing lender exchange and the LMS searches and other things like it. But here's why I'm not being paid by lawyer checker, by the way, sadly. But here's why I really think this is a big deal. Lawyer checker isn't the same as lender exchange and the other similar checks. And the difference is that those other checks are self-certifying. So if you were a fraudster and you were running a fraudulent firm, then you would be self-certifying your fraudulent bank details, which is a really big difference between that and lawyer checker. Lawyer checker is an independent verifier of a firm's bank details, and not only that, but it checks other things with it, like websites and all sorts of stuff. They'll tell you about what they do differently than the others than I will, but I'm quite serious about this. It's a charge that's £10 plus VAT. It protects you. I think it should be made every single time that you send out money to somebody, even if you always use Joe Bloggs on the other side. And the reason I say that is because you don't know what alerts have just been made to Joe Bloggs LLP that morning or that afternoon as you're sending out your money that lawyer checker is picking up on. And the really key part here is we don't have time as practitioners to sit and look at every alert that's coming out of the Law Society. We just don't have the capacity to do it. And even if we did, you wouldn't want that responsibility. But the SRA is linked in directly to Lawyer Checker, and they check that sort of stuff. So even if you always transfer money to Joe Bloggs LLP and you know their bank details, really sit down and have a think about it, about as a firm, whether you want to make sure that you're only doing one every so often or whatever your internal decisions are. Have a look at it properly instead of just assuming that lawyer checker is a fee that you don't need to pay. And the other thing I would say, of course, is that your clients will happily pay that £12 because you will be explaining to them why you're spending their money looking after them. And quite frankly, if you were sending me a lot of money or you were buying a house on my behalf, I'd rather pay a £12 fee than I would not if I was going to be safe. And my final point about it is there is going to come a point, and it's not that far in the future, where the professional indemnity insurers, who we are in conversation with fairly frequently, will start to get a bit to the point where they say, look, this, whatever this I'm pointing at is, well, this is standard practice or available to you in the marketplace, and you haven't been doing it. Why? And there's also a point, and at that point, you're going to have to explain why. But if you know, or you now deem to know, of course, that for example, some search is better than another search, then to be honest with you, do it. And you're in this game to protect your firm, to protect your clients, and to protect yourselves. I always advise lawyer checker, and I really do understand that I sound like I'm paid by them, and I'm not. So the other thing, of course, is to check with the digital badges. It surprises me how many young fee earners and fee earners on the coalface don't know about the digital badges issued by the SRA and the CLC. But anyway, those two practices would pass your relevant checks. The document risk assessments are new. I'm so sorry about the slides, by the way. I'm going to try doing it with my mouse instead, but I'm a bit anxious that I'm doing the wrong thing. And anyway, I'm just going to carry on talking and you get the slides afterwards. So the document risk assessments I've put down on my requirement for 1.4 property and mortgage fraud. And I think actually leasehold policy is 1.5. But anyway, document risk assessments, I've already spoken to that. Make sure that you are doing them. Make sure your teams are doing them. More than that, make sure you've written them down. Either have a standard form that fills in or a standard form that you've inserted into your case management systems. You can then, if you're on case management systems and you are wanting to do this kind of thing, you can make sure that you have built behind the systems who signs the risk assessments at the beginning, the middle and the end, and the date that they're signed by, so that you have a proper trail of how to do it and when to do it, or who did it rather. And it's not to make sure everybody's frightened, but it's to make sure everybody starts taking it very seriously, because we're really into this as lawyers, that we're doing our job properly. We've got such a big task. We have to look after clients. We have to liaise with estate agents. We have to do X, Y, and Z. We don't get paid very much for it. We've got a lot of admin to do in these files. We've got a lot of property law to do. And then on top of that, you're also asking me to do another task now, which is a risk assessment 3 times. And the truth of the matter is, yeah, I am. I'm actually saying to you, it's more important at the moment than anything else, because you're doing it anyway. Your instinct as a solicitor kicks in, and you know when something smells funny or when it feels absolutely right. And if you're too busy, or your teams are too busy, at least the risk assessments give them a pause and a break. And if something feels odd to them, please get them to come to you and say, as heads of department, I'm sorry, but I think this is a bit odd, and I'm going to have to get somebody to help me look at it. And that is the way that you're going to protect yourselves. There's a red flag list that is circulated by Rob Hailstone from the Bold Legal Group. If you're not members of the Bold, I'm really sorry. I really sound like I'm actually selling everybody else's wares and not my own. But if you're not members of the Bold Legal Group, I can't recommend it highly enough. I think it's £30 a month. And the intel that you get from Rob Hailstone is amazing. And one of the things he's got is a red flag list. And then, of course, there are new documented procedures needed for enhanced ID checks for clients when there's a high risk of fraud, and for acting for the buyer if there's significant risk of a fraudulent seller. And then, of course, it also talks about training to all relevant members. I will say something about training. I know that you train your staff, and I know that you can train, and then somebody in the corner will say, I still don't know how to do it, and you want to smack your head against the wall and say, how many times have we trained you? But the truth is that it needs to be trained, and then trained, and then trained. And possibly one of the questions to ask, which is a really good question when you're training people, is to say a month later, what do you do differently now, having had that training that you didn't do before? And if you're doing those kind of follow-up questions, you'll understand very clearly from your staff whether what you've got in place is working, whether you need to amend everything or whatever. So then we come on to requirement. I've actually got here the right slide for where I've spoken up to now. Requirement 1.4, leasehold policy. I actually think it might be 1.5, and I've done that incorrectly, but I will change the slides and get Aisling to send you out the correct slides. And again, the CQS official requirements are on the slides for the leasehold policy. We need to advise the client regarding the length of term remaining. We need to advise the client about the ground rent and service charge. And we need to advise the client about rent review provisions and how the rent is calculated. And you'll know why this is in the CQS policy. It is because we have recently, in past couple of years, really come to grips with the fact that we're not giving, as a profession, possibly all of the leasehold information to clients that they need, specifically with regards to escalating ground rents. And it's one of the most hot topics that is being now presented to the insurers for claims against firms' indemnity policies. And one of the things that I was taught as a young solicitor, which let's pause to laugh, might have been 27 billion years ago, was that if you're advising a client on negotiating a new lease, or you're buying in for them an existing lease, you've got to tell them about all of their financial liabilities going forward. So their repairing obligations, and whether there's a service charge, and whether there's a sinking fund, and what they're not just paying £150,000 for the lease, but they're also going to be responsible for, say, £3,000 a year, because it makes a massive difference. And I remember that very distinctly. I remember being taught that, and remembering that the partner who taught me was a great guy at the time, who basically also said, and if you're responsible for something in that flat, you've got to know, haven't you? And him sitting there and explaining to me in words of one syllable that if I was moving into a flat, what would I need to know? That's not a bad thing to sit with your teams and do, actually, because it's very easy for us to just rattle off what the covenants and conditions in a lease are without actually standing back and thinking, what does a human being in that flat need to know about? But one of the things that I would also add to the purchase of leasehold property policy, of course, is how you approach the landlord, the managing agent, and the other party solicitor, inquire about their fees for the leasehold inquiries, request a copy of the building's insurance schedule, request information about the service charge, make any inquiries about whether major works are proposed to the building in the foreseeable future, and requesting confirmation of whether the service charge or any other monies due under the lease are paid up to date, or whether there are any arrears. Of course, that's what you ask. And then, of course, you would ask for money on account from the client. And once you're in receipt of cleared funds, then you pay the managing agent or landlord or management company the relevant fee. When you've got all of that information, you would report to the client, of course, on the length of term remaining, specifically if it's less than 75 years, and the covenants and conditions in the lease that we've just been talking about, and the financial liabilities that we're just talking about too, with regard to insurance, rent and premiums, and ground rents and other monies due from time to time. That in particular, what lawyers are not that great at is their calculation of escalating ground rent fees. And so we need to be very careful about how we're telling clients about that, because it looks so innocuous sometimes on the face of documents, doesn't it? You start maybe with £10, and every 10 years it doubles, and you look at it and think, yes, so what? And then, of course, by the time you've done the calculation, it seems that the client's paying something ridiculous like £15,000 a year in ground rent, or 20,000, whatever it is, which, of course, you must explain to the client, if that is the case, that it's not only going to affect them, but it's going to affect their ability to be able to sell the property. The other thing that I would put in my leasehold policies, is possibly something that about about the Housing Act 1988, whether it applies, and it applies, of course, if there's ground rent of more than £1,000 in London, or £250 more outside of London. And if the ground rent is already those figures, or will escalate to be those figures during the term of the lease, then you must be telling the clients, and it should be in the policy that you will do it, that if they are ever in 2 months or more arrears of ground rent, whether the ground rent has been requested or not, the landlord can issue legal proceedings against the owners for the owner of the flat for the arrears. And if the arrears are not paid before the court date, the court will make a possession order for the property in favour of the landlord, come what may. It's a terrifying little loophole in leasehold law. And what you need to be telling them very clearly is, if it applies to them, they have to make sure that they pay their ground rent on time, always. Of course, if your client's purchasing a leasehold property with the benefit of a mortgage, then your joint client is also the lender, and you have to also report owner's terms and conditions to them, since they're an equal client of your firm. That's something I would definitely put in the policy as well, how you're going to report to clients and what you report in the clients. What you report to the lender, sorry. I would personally put in that you're reporting concerns to the lender before exchange, and your policy as a firm is that you will obtain clearance to proceed with any issues you've raised before you exchange contracts. Of course, each lender's specific requirements in Part 2 are very different, but it's certainly worth putting in there that you will, as a policy, the fee earners must check with Part 2. I'd also put in the policy that any necessary negotiated deeds of variation must happen before exchange. You've got to draft your deed of variation and attach it to your contract, I would say, or refer to it in the contract, as well as any retentions that you might have to deal with on the lease. And again, as long as all of that stuff is written in the policy that you will be dealing with it before exchange, then I think you've got a strong policy there. And only finally on the leasehold, I would say that the last point on leasehold policies would be to say any deeds of variation and retention, once your client and the lender client are happy to proceed, at that point you can proceed with the transaction. So let me come back to my biggest fear in life, which is slides today. It's not always slides, but it is today. And see, there we go, reporting. The next policy that I've picked up because it's interesting and very new is reporting matters to lenders. Now, the requirements, again, are what I've put out on the slide: to use the lender's specified reporting form where available, to identify the nature of the matter being reported, to provide appropriate legal advice, and to indicate what action can be taken to minimise the risk for the lender. That's what the CQS have put as they want to have in their policies. I'm going to go a little bit deeper into that and say that, that in your policy, I think you should state very clearly that it's your duty to keep the lender and the borrower fully appraised of all changes and errors throughout the course of the transaction. I think that you should have in your policy that you are going to inform the borrowers, or do inform the borrowers rather, not going to, of your obligations to the lender should anything arise during the course of the transaction which would adversely affect the lender's security over the property. And if the borrower, and state also that if the borrower does not want you to disclose any information on a case, that you would, as a fee earner, refer the matter immediately to your head of department. So I think that's a good thing to state out in the policy, because you want to make it very clear that your duty is to protect the lenders from fraudulent activity and to make sure that they are securing their mortgage over a good and marketable title. And that's what you want to tell your fee earners too. I would list examples of situations that might put your security, or their security rather, over the property at risk, although of course it's not a definitive list. So I would include a lease term that's shorter than the term accepted by the lender, subsequent charges or restrictions on the property at HMLR registry, third-party gifts which haven't been detailed in the mortgage offer, changes in the price or financial terms of the transaction, occupiers that the lender's not aware of that aren't set out in the mortgage offer, whether there are any adverse title matters, whether the lender's actually even issued the wrong type of mortgage, e.g. it's a standard mortgage, but the client intends to rent the property out as a buy-to-let and needs a buy-to-let mortgage, and whether or not you've seen the valuation or any kind of survey. I think you should also have in there that the firm is on a number of lender panels and that the head of conveyancing is responsible for dealing with those lenders and for ensuring that the firm's procedures are followed when dealing with lenders and mortgage work. Throughout the course of the transaction, you could put in the policy that should any matters come to light that may affect the value and its physical condition, that you will, as a firm, the matter must be reported to the lender unless it's already detailed in the mortgage offer, and where appropriate, that you would be giving advice to provide to the lenders as to how it would be possible to proceed. For example, there's no documented right of way, and we suggest that an easement should be entered into before proceeding. Also, I think you should have in your policy that you will refer matters back to the lender's valuer or surveyor for valuation considerations at appropriate times. One of the last things I put in this policy, that if you need to make a report to the lender, you've got to check their own particular routes and different procedures and reporting forms, because they're all different, helpfully, and that you will have in your policy that reports to the lender must be made as soon as possible and as soon as they come to light, and that you will make sure that you've waited to hear from the lenders before you proceed to exchange. And that you definitely, possibly the last thing to put in, I would put in that the cotton or the rot, the report on title and the certificate of title are only submitted, so you're only requesting funds once the lender's confirmed that you are happy to proceed. So one of the last little points that we picked up is that requirement 5.6F is a requirement to put in at post completion that you are going to be telling your clients about HMLR Registry's Property Alert Service. So it's a fairly, it speaks to itself, this one. The requirement is to draw the client's attention to HMLR Property Alert Service and other fraud guidance published by the Land Registry. It's a good thing to tell clients, but actually get them to do it themselves again, because they're then responsible, especially, and tell them this, but they're responsible for keeping their details up to date, Land Registry. I don't particularly like the thought of us all putting that comes back to you, because you might never be able to get hold of them, and what would you do after that, for heaven's sakes? So next stages, I happen to know that Lexcel accreditors and inspectors are being talked to by Law Society with regard to CQS, which is helpful. And they are hoping to start with inspecting 50 firms a year. So it's not massive, but it's 50 firms is more than it was doing, more than the Law Society was doing. And it's something to talk about and to think about, isn't it? Because at the end of the day, don't let one of them be you without being prepared for it, is what I always think. And the biggest thing, which is not quite here yet but is coming, is don't just have the policies sitting on a shelf. Bring them into the way that you're doing your transactions, put them into your checklists, talk to your staff about it, drive it through. So I'm going to say something, but we have written these particular policies. If you're interested in purchasing them for us, just contact us and let us know. I'm sure you can do them yourselves. It's very easy, but I always think sometimes that we are so busy in this day and age. It's taken me quite a while to write them and to think about what I would put in if I was you. They're written in words, so you can change them as much as possible. But yeah, if you're interested, let me know. And let me just quickly check before I come back to the end of it to say, somebody's actually said, should the SDLT, I'm going to go through the policies. And I've just seen Debbie Everett say, yes, please, can I have the policies? Just send me an email to the inquiries at the CS Partnership, and I'll happily deal with all that. So let me just go through. I'm so sorry, Vicky and Joe, remind you, I hope we've sorted that out with your comments about whether you could hear. Somebody asked whether the SDLT advice sheet should be signed before exchange or completion. I think that's a great idea. Yes, there are firms that we work with who definitely do that. So the way that I structure, I might be talking way outside of the remit of this call now, but the way that I structure, or we advise clients to structure their starting, is that I always I like to send out the engagement letter first and get that signed, usually electronically. You're all on InfoTrack. You can all do that InfoTrack wise. Clients really like just this day and age to just click and send it back, then you're sorted. Then you can send out all of the forms that you require. So the SDLT advice, the form that, well, I call it Form 1, but it could be called anything. The form that goes out to say, please check your bank account details. All of that extra stuff. I would send that definitely and get it back. That's a brilliant idea. And definitely before exchange. And the Housing Act 1988 and the 2-month overdue. Yeah, absolutely. I will definitely contact me about that if you're interested, Anise, and I will definitely elaborate more on that. In fact, I've put it into one of the policies that I've written anyway, because it's quite, just contact me and I'll talk to you about the ramifications of the overdue ground rent on that. Any other questions? Does the SDLT also include Welsh chat? Yes, I would say so, definitely. Because what you're doing is you're sending the form out, you're writing the policy to cover all SDLT, cover Welsh land transaction information in the policy too. Yes, and I will, all of you asking me about the policies, yeah, by all means, send me emails and I'll tell you. The price for them all is £250. Do you recommend, hang on, somebody's just sent me a message in. Do you recommend other checks alongside Lawyer Checker, or simply rely upon Lawyer Checker? I wouldn't just rely on Lawyer Checker, actually. This gives me a chance to prove I'm not just a Lawyer Checker bird. No, I wouldn't just rely on Lawyer Checker. I would do Lawyer Checker for sure. I would also check anything else that's available to you. So I would definitely be looking at the other firms' websites and seeing whether they've got their digital badges on. If you've got Lender Exchange, or you're part of LMS or whatever else that's available to you, I would do that as a belt and braces. The thing is, you'll get I hope, I don't know if you will, but you'll get very used to double checking up on everything. But yeah, I absolutely would do as many checks as you can and document it. So even if the document is just a pre-printed form and you're printing it off and saying, have you done this tick, have you done that tick, and the dates of them, and then the initials of whoever signed it, absolutely. I would do as much to protect yourselves as possible, because it's not an easy world, is it? And there are people, I understand that there are people sitting in different parts of Europe whose job it is just to hack us all. And I'm not saying that we're ever going to avoid all of that forever, but I am saying there are really good things that you can do to put yourself in there. So, and presumably, somebody's just said, presumably a sophisticated fraudster could just copy the digital badge. I kind of think so. I have no idea. You can tell that I'm not very, you can tell that I'm not even very particularly able to do my slides, so let alone copy a digital badge. But yeah, I do. It's not, I come back to that thing that I always say, from a practical perspective, and if you talk to your insurers, they'll say the same to you. It's not to say that you should be combating every single thing that a decent fraudster would be able to do. It's not. What we're saying is, make sure that you've covered yourself so that, I haven't told you this, but as I started in my, in Panoni, when I was running the department, and we ended up submitting 4,000 transactions a month, in my first week, I sat opposite the table of soccer. And I went in quite able to charm them and thinking it would be nothing. And I'd been there a week. So what they were coming to talk to us about was nothing to do with me, and, all of that sort of jazz. And I have to say that within about 3 minutes of talking to the two policemen on the other side of the table, it was the first time in my life that I thought, I'm going to prison. Oh my God, I'm going to prison. I didn't even do anything about it. That's why I'm so obsessed about telling firms about this stuff. It's not that it's to protect you. Just make sure that you have done everything so that you can answer those questions should you ever be asked to answer them. That's what I'm trying to say. So SDLT forms, I'm just reading a question. SDLT forms are submitted online. Clients provide their authority to us to deal with it at one time on their behalf. Should we actually get them to sign a hard copy? I don't think a hard copy is necessary. I think you could probably send them out a copy by PDF, or I'm not sure how you do it online. Something that shows that they've seen it. So if they see a hard copy, or however you do it, I don't think they need to sign the actual hard copy. I think or your signature online is fine. But I think that to do that, you want their authority to proceed. And to do that, I think you should have a copy of them. They should have seen a copy of what you are going to be signing on their behalf. And yes, I do also have a template for SDLT advice sheets, and I'll send that out to you. So Aisling has come back and said, and she's quite right too, because she said half an hour. I did warn you. I'm sorry. I keep talking. But if you've got any other questions, please just ask us, or ask Aisling, and she'll pass them all on, and I'm happy to answer all of them. I'm really sorry about my ability with slides. You will get the slides. Somebody's just asked quickly, is there a solicitor responsible for payment to SDLT? You're not responsible for the payment to SDLT, as I understand it, but you are responsible to your lender that it's going to be sorted, and that more than that, that the property is going to be registered properly at land registry. That's the point that gets you. So you have to make sure that you're in charge of submitting the SDLT, because you are responsible for making sure that it's done, so that the land can be registered properly at land registry. So just take it all on board and say, yes, you are.
Okay, Sarah, I think we should finish up there. Hello?
Hi, I'm here. Sorry, I was just having a drink. Sorry.
Perfect. That's fine. So, Sarah, thank you so much for all your time today, and for everyone who has joined us, and I hope you all found it informative. As Sarah has mentioned, any other questions that you do have, please send them on to myself or Sarah. We will be sending out all the slides with any of the information that you heard today. And if you have any other questions, please contact your account manager, or again, myself or Sarah. And thank you. And we look forward to everyone joining us again for another webinar soon.
Thank you.
Thank you.